Commissioners, go right ahead. Thank you.
Good morning, everybody. This is Chair Michelle Espinoza, and I'm calling the Real Estate Commission meeting to order on October 1st, 2024. It is 9:01 a.m. Director Waters, may we have roll call?
Autumn Rubal.
Here.
Michelle Espinoza.
Here.
Renee Lind.
Here.
Erica Doyle.
Here.
You have a quorum.
Great, thank you. May we get a motion to approve the August 6th, 2024 Real Estate Commission meeting minutes?
I motion to approve the minutes.
Second.
Thank you. Any discussion? All those in favor?
Aye.
Aye. Aye. Any opposed? Motion passes for approval. Are there any public presentation of issues not on today's meeting agenda?
Commissioners, this is David Donnelly from the division. If I may, I'd like to put up a poll for attendees that will allow them to sign up to obtain continuing education credit should this meeting last the requisite time frame. And so if with your permission, I'd like to launch that poll now.
Yes, please. Thank you, David.
While those are running, commissioners, please feel free to carry on with business, and I will end the poll after some of the answers slow down here. So thank you very much.
All right. And David, are there any, is there anybody raising their hand for public presentation?
There is not at the present time. However, anyone that would like to speak, you can select the raise hand icon in the Zoom client at the lower part of your screen, and I will be able to unmute you. We do have one individual that has raised their hand, commissioners. That is Julia Rayburn. Julia, I have allowed you to unmute, and you can go right ahead and speak.
Good morning, Julia. Can you hear us?
Are you able to hear me now?
Yes, thank you.
Excellent. Thank you very much. And thank you for having me. It's a real pleasure to speak with you and the commissioners today. I would like to raise my voice in support of the proposed commission position statement on data protection. I'm in the wire fraud game and an expert in that space, wire fraud, particularly in the context of real estate settlements. And this is a really critical issue that is affecting so many Coloradans, especially home buyers in the sector now. And so the real estate agents of Colorado have an obligation and an opportunity to really help that sector of the community to prevent wire fraud. And the position statement is going to go a long way to advance that goal. So I've presented a white paper to Marsha and the commissioners, which I'd be happy to share more broadly if that would be beneficial. But I'd like to offer myself to answer any questions on this topic, given that it is something that really affects all of us.
All right, thank you. Yes, and we were forwarded that, so thank you so much for that. Commissioners, did you want her to expound on that, or were you able to read that and we're good?
I think we're good. We read it.
Julie, I do appreciate it. It was very well thought out and prepared for us to review. So I do appreciate all of that work you put into that and looking out for our community.
Yeah, absolutely. It's very prevalent. It's about 1 in 10 consumers get targeted for wire fraud. And so it's just such a widespread issue that we all really need to band together to help prevent it and stay one step ahead of the fraudsters.
Absolutely. Great. Thank you so much, Julie, for joining us today.
Thank you.
David, was there anyone else?
Not seeing any other hands that have been raised at this time, commissioners.
All right. Let's go ahead and move on to policy matters.
So commissioners, the first item on your agenda is the proposed position statement on data security and privacy. This would be CP30. Melissa Phipps is here today to just kind of give you an overview. She was actually the one that drafted the position statement. And then after Melissa, we have Tracy Dowd with the Colorado Bureau of Investigation. She is a special agent. We invited her to speak to you about cybersecurity issues as well.
Okay, great.
Good morning, commissioners.
Good morning.
As I'm sure everyone is aware, and as Ms. Rayburn pointed out, cybersecurity concerns are a huge and widespread issue in today's industry, unfortunately, and data breaches are not at all uncommon, and they can lead to devastating effects for both brokers and consumers. So it's obviously an issue that the division feels is important to take head on, and we're trying to take some proactive measures to put some standards in place for brokers to abide by in their everyday practice. And so that's why we've got the position statement draft here for you today. And just some background, in our last round of rulemaking that was done in January of this year, the staff had proposed a new draft rule that basically just attempted to put in place some minimum standards and laid out some minimum affirmative steps that we felt were important for brokers to take to protect personal identifying information and just any kind of sensitive data. And there were some concerns expressed about enforcement of that rule and whether brokers could really be expected to comply with all of those standards that we were proposing. So ultimately that rule wasn't adopted. And so that led us to where we are today. We're trying to put in place a position statement, and that would be just a resource for brokers to use to have some guidance on what the division staff and hopefully the commission feels are just best practices and principles that brokers should adopt in their everyday practice. I won't review that position statement in really any detail. It's actually pretty short, so hopefully you guys have had a chance to look at it before today, but it's really just some basic common sense principles that, you know, frankly, probably every consumer should be using in their everyday life, that we just think is good guidance for brokers to put these into daily practice. We're really just encouraging brokers to be proactive. You know, brokers take consumers as they come, and many consumers may not be aware of a lot of the risks that are out there. They might not be savvy about cybersecurity issues. So really, we're just hoping to encourage brokers to be proactive, take the steps that they can to protect their data, protect consumers' data, and just kind of try and, again, keep using that word, but be proactive and kind of take on the issue to the best of their ability. So I'm happy, as Marcia said, I did kind of take the lead on drafting this. So I'm happy to answer any questions that you guys may have about it. Probably can wait on that until after Ms. Dowd gets a chance to speak. But again, if you have any questions, feel free to let me know. Thanks.
Thank you.
Tracy, can you unmute?
Yes, can you hear me okay?
Yes.
Okay. Hello, everyone. I'm Agent in Charge, Tracy Dowd. I'm with the Colorado Bureau of Investigation. I'm in the high-tech crime unit / economic crime unit here at CBI. And part of the work that we do in our unit, we work with a lot of governmental agencies, large corporations, small business owners, individuals, everyone on the detection and prevention of fraud and cybercrime. In review of the position statement here on data security and privacy, I guess I wanted to provide a brief statement from a law enforcement perspective in support of this position statement. Over the past 10 years or so, our unit has worked directly with the real estate industry, all sectors, specifically as it relates to wire fraud prevention, wire fraud recovery efforts, and also cybersecurity best practices. So our interest in providing training and outreach to this industry has always stemmed from the complaints that we usually get from wire fraud which is typically buyers in a real estate transaction. When we receive these complaints, I think it's important to know that on our side, what we see is that someone has typically clicked on something they shouldn't have, right? That could be a PDF that contains malware, a link, or even an Adobe document can contain malware, which allows the bad actors to have essentially access to a person's email, right? That's the email compromise. That's the data breach that we see most frequently. It's important to know that we have also worked with hundreds, I almost would say thousands of real estate transaction wire fraud scenarios over the years. And the most unfortunate thing that we have found is that real estate agents and transaction coordinators tend to have the highest likelihood that their email will be compromised in a real estate transaction. That's what we see on our side. And so if you imagine, if you will, the fraudsters having a playbook, one in which they know this industry inside and out. And we know that because we continue to see them exploit this industry in different ways, from vacant land scams, right, to email compromise, wire frauds, vendor payoffs being redirected. They know the mechanics of a closing, correct? So what we know is then, if you think about this, if they have a playbook, which they share with each other, they're always going to choose the strategy of the path of least resistance. They're always going to choose those with the lowest levels of security available to them. And so when we're out there, and I do a lot of outreach and training in the real estate industry, and I know sometimes I leave and it's kind of scary, but the feedback that I get from real estate agents after these trainings is the majority of them prior to the training did not necessarily understand how vulnerable they were and are to this type of behavior and this type of phishing attacks or email compromise. And more importantly, they are so eager to know how they can protect themselves from these things and all the resources and steps to take to do this. So I guess if I look at all the training that we have done and the information that's in the position statement, the trainings that I've provided to the real estate industry, and I continue to do because it's something, again, I'm very passionate about, we teach to these things that are in the position statement. So this mirrors what we train here at the CBI, because that's what we are seeing from victims. So I guess from my perspective, and I'll always talk more about this topic again, but if you look at cybersecurity, as we all know, it's not just one thing we do. It has to be all the things that we can do to protect our information or that of our clients. And so layered security, kind of what's laid out in this position statement, it's very simple in the way it's laid out. And I think it's a step in the right direction towards hopefully making a change in this industry, because quite frankly, in my opinion, this industry will continue to be exploited by fraudsters until we make changes, and the financial loss is just not sustainable, nor is it good for the integrity of this industry. So I open myself up to always provide training in this area, which we do. But I think that this position statement is an absolute great step in the right direction towards making this change and hopefully a change in further regulation. Thank you.
Great, thank you so much. All right, commissioners, do we have any questions?
Well, we've had a lot of discussion about wire fraud. However, title companies are the ones that mainly deal with the wires. It's not something a real estate agent is or should be dealing with. And I'm kind of confused about all the discussion about that when it's not something that is on their plate. It's in a different department, division, however you want to say. It's title companies. So it's not something we're telling our clients, real estate agents are telling their clients, here's the wire information. That's something that's coming from the title company.
Correct. And may I speak to this?
Absolutely.
For clarity on this, from my perspective, the real estate agents are the mechanics of this, right? The real estate agents or whoever's email is compromised. And a lot of times what I'm saying is we see that the agents or brokers are the ones whose email is being compromised. From that point, intelligence is gained by the bad actors to see who's involved in these upcoming transactions. And that's when they reach out and insert themselves and introduce themselves to the buyer. So it's that point of contact from that initial email compromise, which is what I train on, is to be the most important thing for not just brokers, but everybody because that's where the bad actors are gaining intelligence to then reach out to the buyers for them to send money to different places, if that makes sense.
Okay. Okay. This commission position statement is we have a lot of shoulds in here and not have tos. Is this a recommendation? Is this something you have to do? There is a lot of information in this position statement and a lot of requirements. So are these actually requirements? Are they suggestions? I'd like clarification on that.
So it's a position statement, which is there just to provide guidance. It does not carry the effect of a rule or a regulation. So these are best practices, essentially.
Okay, but I thought position statements really are considered a rule and that somebody is going to get in trouble for this. So is every case that comes through, now we're going to look to see if they're complying with this? Is every single person now going to be getting in trouble for not having a VPN or not doing this or having a Gmail account? How are we addressing this with getting people in trouble and fining, etc.? I think it's extremely over the top, and I don't think most agents can comply with this.
So we have never cited anybody being in violation of a position statement, and you cannot fine them or discipline them for not following a position statement. Now, if we had a complaint where a real estate broker, we were able to document that they did a horribly bad job at managing people's personal information, then you could probably cite them as being unworthy and incompetent and impose discipline upon them for that. But position statements are strictly guidance. This is there to help the brokers with their day-to-day business. It's nothing that you can discipline them for, and you've never disciplined them for a position statement.
Okay, the PII, I was looking at what Scott from CAR sent over. The definition of PII is I was reading is that then your name, your email, your phone number are not listed under that. Is that true or not?
So I'll let Melissa speak to that, but emails are part of personal identifying information.
But I don't know. The letter that Scott sent over, the definition that was referenced, I may have to pull it up because I thought that in the name, email, and phone number were not listed as PII.
Melissa, would you like to speak to that?
Marsha, I believe you're correct. I'm trying to pull up the actual definition of the law so I can just read it, but I am Social security number, personal identification number, password, date of birth, and
Right, so that doesn't include your name, email, or phone number. This is kind of confusing.
well, I guess I'm to take a step back. I don't understand what you're reading from and what exactly you're saying is confusing.
Well, the definition, we're really targeting here. A lot of this discussion is having to do with email and getting different types of email and making sure the email is secure, et cetera. And it's information from the client, but we're talking about personal information, but yet our personal identifying information on that list does not actually address your email. I just think it's a little confusing, and I think what we've got in here, okay, maybe it's a recommendation. I think most of the things in here are going to be very difficult for the average licensee broker to comply with. And I mean, even if we go over to, this would apply to property management as well. Okay, we all have different software programs. I can't control what the software company that we're using is doing, and this position wants you to do that. I just think it's there's just so many things in this position statement that I don't think that can be met. So if we're just looking at it, okay, this is a recommendation, this is a best case scenario, that's one thing, but I don't think it's attainable for most brokers.
So Renee, to give you just kind of a quick basic definition of personal identifiable information, it's any information that can be used to identify a person either directly or indirectly. So some examples of PII are name, address, social security number, telephone number, email address, gender, race, birth date, geographic indicator, and biometric records such as fingerprints, retinal scans, and voice signatures.
Okay, well, I was looking at Scott's information and he had a definition. It didn't include that. So that's why I was.
And so those were comments supplied by the Association of Realtors. Melissa researched the laws.
Okay, because I don't think most brokers are giving, they're not asking for socials. There's not a reason for them to be asking for that. So it seems like the main issue is just the email account, and that once you email someone, then someone can hack into it and get that. That seems like that is the main issue. Is that correct?
I think that's one of the issues. I don't think that's the sole issue. And I don't think that most consumers are aware that by providing their broker with their email address, they are setting themselves up potentially to have to then deal with Tracy because they've become a victim of wire fraud or some other type of real estate scam. The whole purpose of this was to provide the general population of real estate brokers with some guidance on how they can manage personal identifying information. It's not a regulation. If they don't follow it, we don't ever cite anybody for a violation of a position statement. I mean, if it's widespread, at some point, we may come back to the Real Estate Commission and ask that they adopt a rule. But I do think that there is some responsibility with the real estate brokers on how they manage their clients' data.
And Marcia, just for clarification, this position statement already exists. We are just fine-tuning this position statement.
No, this would be a new one because
It's all new.
We had presented you with a rule back in February and you didn't adopt the rule, and you had indicated to us to look at doing a position statement.
Okay.
So that's where we're at today.
So the red in the draft, I guess that's where I got confused.
So Melissa had drafted the position statement, sent it out there for stakeholder feedback, and then that is applying some of the stakeholder feedback.
Gotcha. Okay.
Melissa, it looked to me like a lot of what CAR had recommended has been incorporated in this. Was the revision sent back to CAR, and did we receive additional commentary from them?
The revision was not sent back to CAR, no. Because I do believe, like you said, we did adopt most of their input.
I think that overall, I like a lot of it. I don't want it to be so onerous as Renee is stating that it can't be accomplished. I really appreciate Julia and Tracy's comments, Tracy's in particular, because we are hearing so much about this. And I don't think there's a realtor on the planet that would not want this to happen and doesn't, well, I know we're educating everybody, but we're really trying to make sure that we're seeing it. But the situations are so tiny that are allowing people to get into the public's email, to our email, to title companies. It's, we do need the education out there, but I would really like to take and make sure that these changes have gone back to CAR, because you're trying to get the information to the realtors. This is who you want this to go to. I would kind of like this information to go back for additional comment, make sure we're getting everything in there and that it's doable to a large degree. I like Renee's comments on that.
Respectfully, commissioners, this is not targeted just at realtors. We deal with the broader real estate population. It's not just the realtors. They were given an opportunity to provide feedback. I don't know how many times we have to go back and forth with the realtors in order for us to just provide some guidance to the broader brokerage industry.
I may have misspoke as far as just the realtors, but I think these comments are excellent on how you're supposed to be able to implement them, whether you're a large brokerage, a small brokerage, assisting in this.
I think there needs to be something more in the beginning or the top with some specifications that these are recommendations, something with that, because I still think there are a lot of people who are going to have a hard time complying with this. And
So
I think
Commissioner,
we need to make it clear.
that's the whole purpose of a position statement. The purpose of a position statement has not changed through this. And I think there was some obvious confusion in the comments that you got from the realtors that they didn't appear to understand what a position statement is. It is strictly there to provide guidance. It is not the same as a regulation, a rule, or a statute. They don't have to follow the position statement. It's out there to help them.
Okay. Just maybe I'm playing devil's advocate, but you also said that if somebody comes in, we get a case and they have not done what this says, you said we could find them, incompetent, which then is an issue and something that they could be fined on, and I hate to say not charged with, but written up for. I'm having a hard time that if that's the case, almost everybody who comes in is going to have an issue, and where they're going to be incompetent in this in some manner.
So to clarify, what I said was if we had a complaint where a broker had done a horrible job at managing somebody's personal information, then you could look at deeming them to be unworthy and incompetent and disciplining them for that. I didn't say that they didn't follow the position statement. And I think you have a good case today of an example where somebody didn't do any research to actually verify that it was actually the seller, and that's a concern.
Mm-hmm. Well, I've been on the commission 5.5 years, and Renee, have never seen a position come up where that's what we've used for discipline. Or even referred to, when we're making our decisions. And I think, and I don't know about the educating the broker community of what the position statements are. I don't know at the beginning, where do these rest, Marcia, as far as resources for a broker? Are they just on the website? Are they in the manual?
They're in the manual.
Yeah, they're in chapter 3 of the manual, and they're also available on the website.
So in that space, is there an opening part where it gives guidance on what these position statements are used for, or what their purposes are?
I don't think there is a description at the beginning of chapter 3 about what the position statements were, but strangely, this is the first time that this kind of broad misunderstanding has happened.
Right. I'm wondering if that's something maybe could be added on the website or something of kind of what Renee is asking is, clarification of what these position statements are, commission positions are for, and they're for best practices, that kind of thing.
And
Not,
I'm sorry,
ahead.
Commissioner Chair, this is Gina Simons from the AG's office. I'm sorry to interject during this conversation, but it sounds like the commission is grappling with concerns about how position statements are used by the commission and maybe the legal implications. If they want to table any vote on the position statement pending an executive session to talk about that, if there's some other issues that the commission is going into executive session for, we can certainly address those questions in that session and provide some advice on how position statements have been used historically by the commission or how they're used to inform their standards and enforcement of their laws and regulations.
Would you like to table this and go into executive session later to discuss that with council?
Sure.
Erica, does that make sense for you?
That's fine by me, sure.
Okay, so let's table this to the end of the meeting when we can go into executive session.
So commissioners, the next item on your agenda is the 2025 meeting calendar. You don't need to adopt these. This is just to put it on your radar so that you know what the future dates are for 2025.
All right, thank you.
And then the last item under policy matters is, do you have any agenda items for the next meeting?
I don't have anything. Anyone else? No. All right, looks like we do not. Let's move on to complaint investigations and audits.
So complaint matter A is case number X 2024-24. This is an audit that was conducted by Betsy Meredith. She is here today to answer any questions that you may have. A routine audit was opened on the respondent after an anonymous complaint was filed and then withdrawn. The complaint alleged that there were undisclosed markups. During the audit, it was discovered that the brokerage has an in-house eviction protection program, which I'll refer to as an EPP, for which owners can opt in and out of on a monthly fee and have costs associated with evictions covered. There was initially no disclosure of potential profits. The respondent manages 1,850 doors, and in 2023, 843 owners opted into the EPP plan. The respondent claims the program is a loss. However, he included standard brokerage costs to the cost of evictions when, in reality, the cost should have been incurred with or without evictions. In addition, the markups noted in the lease and property management agreements are vague, and a review of various submitted invoices indicate the markup amounts are not consistent with the information in the contract documents or the website. Tenants are also charged markups. Neither the lease or the property management agreement lists the markup, but reference the website that notes that markups and prices are subject to change. Additionally, invoices were submitted that appear to have charged the property owners more than what they agreed to. Possible violations include 12-10-217-1I, converting, diverting, commingling funds, 12-10-217-1M, violation of any commission rule or this part 4, 12-10-217-1T, undisclosed compensation, 12-10-217-1Q, unworthy incompetent practice, 12-10-217-1W, dishonest dealing, commission rule 5.17, markups must have prior written consent, and 5.9, diversion conversion prohibited. The recommendation is for a final agency order with a public censure, coursework in ethics and legal issues, a fine, probation, and then audits, which for some reason didn't show up on your ESP referral, audits, follow-up audits of 4 within the span of the next 2 years. And like I said, Betsy is here to answer any questions that you may have.
Good morning, commissioners.
Good morning. All right, does anybody have any questions? My question, so Betsy, they voluntarily decided to close, or that was something that they had said at the end, right? That they were gonna close down their EPP plan.
Yes, and I have evidence that they've moved forward ceasing that program and have notified.
Okay. I believe somewhere in the documentation, there have been audits prior to, am I correct? And no one has said anything on prior audits regarding this program?
Correct.
And you may not know, but can you give me some insight on why no one before found that this was a problem?
Sure. In fact, specifically, I was one of the auditors previously. As you know, when we do audits over time, the audit processes change of what we look for, specifically what's going on in the industry. I mean, that was 7 years ago, and we've made some modifications to review things like this.
Okay. And they've never had any prior discipline, correct?
That's my understanding.
Okay.
So is that something you're going to be looking for in the follow-up audits to make sure that the EPP has not been reactivated?
Correct.
I am not, the one thing I'm struggling with here is I don't know if this rises to public censure. One, they've been doing it for a while. It's not been caught on an audit. And I don't mean caught. I mean, it hasn't been flagged in an audit previously. They don't have any prior discipline. They've closed it down. And it seemed like they were very open during the investigation. So I mean, I'm fine with the other stuff. I'm struggling with the public censure piece of it. So I don't, commissioners, thoughts?
I could go either way on that one. If you want to take that out. You know, there were some other issues where things were not disclosed in the, management agreement, the tenant lease, et cetera. There were some fiduciary responsibility issues, but if you want to take the public censure out, I could do that.
Okay. Erica, Autumn, do you have any thoughts or?
Yeah, I'm okay with that. It did seem like they were being very forthcoming, and I could see how there could be some confusion on that if that had been going on for so long and had not been flagged in previous audits. I think that that's reasonable.
Okay. I would like to remove the public censure. And if we're okay with that, can we get, unless there's any other discussion, can we get a motion?
Motion to accept staff recommendation. Yeah, but instead of remove the public censure, make it diversion.
Commissioner Line, I just want to remind you that public censure is not necessarily, removing public censure not necessarily equates to diversion.
Oh, that's true.
We
okay,
can,
so just just remove the public censure and leave it in FAO. Okay, sorry. Okay, so
all right. Do we have
accept staff recommendation with the change of removing public censure?
Right. We have a second.
Second.
Thank you, Erica. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Good morning, commissioners.
Good morning.
Okay, matter B is complaint number 2024-861. On April 22nd, 2024, the respondent pled guilty to one count, class 6 felony of theft between $2,000 and $5,000. The court agreed to a 1-year unsupervised deferred judgment and sentence that includes 50 hours of CMSV and a Discovering Better Choices class, and court costs and fees in the amount of $4,888.50, which has been paid in full. Possible violations include 1210-217-1M, 1210-217-1N, 1210-217-1P, and Rule 6.23. Disciplinary recommendations are diversion, a fine of $500, and probation to run concurrent with the criminal deferred sentence. And Investigator Geske can answer any questions that you might have.
Right. Thank you. Any questions or comments?
I had a question on this. The sentence was deferred for 12 months. Is that over at this point?
Yeah, it looked like it got changed to a 12-month unsupervised. Is that right?
Correct.
And she pled on April 22nd, so it would be 12 months from then.
Okay, so it's still ongoing.
Still ongoing.
Correct.
Okay, so, and it does say concurrent, so we're good there.
All right, do we have a motion?
And move to accept staff recommendation.
Second.
Yeah. Any further discussion? All those in favor?
Aye.
Aye. Aye. Any opposed? Motion passes.
Matter C is complaint number 2024-1085. The complainant, who was the seller's agent, alleged that the respondent provided her buyer client with the lockbox code to gain unauthorized entry into the property. The investigation noted that the respondent did provide the lockbox code to her client, who entered the property without her being present at the property. Possible violations include 1210-217-1Q, 1210-217-1M, and Rule 6.16. Disciplinary recommendations are diversion and a fine of $500. And Investigator Geske can answer any questions.
Excuse me, on this one, there's a remote conflict, so I will recuse myself.
Okay, thank you.
I have written down that there was a step for diversion previously, and I have written down with the fine and the coursework, but I forgot to write down what it was. Was that dealing, what was that dealing with?
Let me see.
Yeah. Was it just classes?
Let me look real quick.
Okay.
The previous commission action was a $200 or a $250 fine and 4 hours of coursework.
But what was it? What was the violation? What was it for?
Let's see.
It was related to a CE audit. Just
Okay,
sorry to
it
interject.
was. Okay,
Yes.
thank you. Right. Okay, well, then I move to accept staff recommendation.
All right, do we have a second?
I'll second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Right, motion passes.
Okay. Matter D is complaint number 2024-1287. The complainant alleges that the respondent provided the property lockbox code to individuals without authorization. Possible violations include 1210-217-1Q, 1210-217-1M, and Rule 6.16. Disciplinary recommendations are diversion and a $500 fine. And again, Investigator Geske can answer any questions.
All right, do we have a motion?
Well, I just have a comment too first. It seems like we're getting these every meeting. And honestly, I don't remember if this has been addressed in the newsletter. I'm not sure if Director Waters could maybe do some article about this in the newsletter, since this is something we are seeing on a consistent basis. You would think people would know this by now, but obviously that's not the case. But I motion to accept staff recommendation.
Second?
I'll second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Matter E is complaint number 2024-851. The investigation noted that the respondent did not properly list the property in the MLS according to the exclusive right to sell listing agreement and did not execute termination documents, which may have put the buyer and seller in financial risk. Although the respondent had signed a listing agreement with the buyer, the respondent treated the buyer as a customer. Possible violations include 1210-217-1Q, 1210-217-1M, 1210-404, Rules 6.9 and Rules 6.14. Disciplinary recommendations are coursework and brokerage relationships, coursework and contracts, diversion, and a $1,000 fine. And Investigator Gusky can answer any questions that you might have.
Thank you. Any discussion, comments?
Yep, I move to accept staff recommendation.
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Matter F is complaint number 2024-1373. On July 29th of 2024, the respondent pled guilty by way of plea of no contest to 1-count felony 5, telecommunications fraud, and 1-count misdemeanor 2, offense of attempted tampering with records. He was sentenced to 5 years of supervised probation and to pay for the state of Ohio investigation costs of $56,000. This is ordered to be paid in a monthly yet undetermined amount. And possible violations are 1210-217-1N. Disciplinary recommendations are diversion, a fine of $500, and probation to run concurrent with the criminal sentence. Investigator Garbardi can answer any questions. And just an update, the co-defendant was sentenced on the 23rd to the same amount of the $56,000. So in conjunction, the two of them will be paying that off, but we don't have any evidence of a payment plan in place for our respondent.
Okay. Any discussion?
I move to accept staff recommendation.
Do a second?
I would second that.
Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Matter G is complaint number 2023-2167. The complainant alleges that the respondent failed to provide her with a counterproposal in a timely manner. Furthermore, the respondent failed to inform the complainant of the counterproposal acceptance deadline, thereby causing the complainant's contract to buy and sell to be rejected as it was not submitted per the terms of the counterproposal. Additionally, the complainant alleges that the respondent negotiated her commission with the listing brokers of the subject property without her permission. Possible violations include 1210-217-1M, 1210-217-1Q, 1210-405, Rules 6.14D, and Rules 7.4B. Disciplinary recommendations are coursework and contracts, a final agency order, and a fine of $3,000. And Investigator Gabardi is here to answer any questions.
I have a question, not on the recommendation, but the brokerage in this case is not actually using the state-approved contract. They have put it on their own paperwork, and the lines on this are extremely confusing. I just have a general question. Is this allowed? The verbiage may be the same, but it was so confusing about the line numbers and the numbers in the boxes. Shouldn't they have to be using the same format as a state-approved form?
I'm sorry, which contract are you referring to?
The contract to buy the
CVS. Okay. I'm
yeah.
just pulling that up real quick.
So the format was totally different, and I was looking for certain line items and numbers, and it was so different than the state form as far as the format and the numbering. I just thought it was extremely confusing, and maybe it's just me.
It does look different, the format. I don't believe that there's any rule or statute about the format, as long as the information is exactly the same as our contracts.
Okay. I just thought it was confusing, and I suppose a buyer may or may not, but okay. So other than that, I move to accept staff recommendation.
Do we have a second?
I second.
Okay. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Matter H is complaint number 2023-1960. On May 18th of 2023, after a 2-day trial, a jury verdict found the respondent guilty of a Class 1 misdemeanor, invasion of privacy, sex gratification. A sentencing hearing was thereafter held on August 15th of 2023. The respondent was sentenced to 24 months of supervised probation. A stay of the sentence was filed. The order granting the stay of the sentence was signed on August 17th, 2023, and an appeal was then filed on September 8th of 2023, and it remains open at this time. Possible violations include 1210-217-1M, 1210-217-1P, and Rule 6.23. Disciplinary recommendations are diversion and a $500 fine, and Investigator Gabarty can answer any questions for you.
All right. Questions, comments?
I move to accept staff recommendation.
Thank you, Renee. We have a second?
Second.
I think I heard Autumn. I think I heard Autumn second. First. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Matter I is complaint number 2023-2320. The seller complainant filed a complaint against her listing broker, the respondent who represented her as a seller's agent in the sale of her home. The complainant alleged that the respondent did not protect her best interests, as she told the respondent that she wanted the rugs excluded from the contract, but the respondent did not notify the buyer accordingly. The investigation found that there were errors in preparing and managing contract documents as well. Possible violations include 1210-217-1Q, 1210-4041, 1210-217-1M, Rules 6.5, and Rules 6.11. Disciplinary recommendations include coursework in brokerage relationships, coursework in contracts, coursework in legal issues, diversion, and a $4,000 fine. And Investigator Peters can help answer any of your questions.
Great.
So I had a question in that, isn't a rug personal property that would automatically be excluded in the contract?
Yeah, if you're asking me, Commissioner Line, that's my understanding of the contract. I think that the issue here was in the contract where it was listed as an inclusion in other inclusions in that line item. I believe, if I remember, it's under the complaint section of the report. In section, it looks like in section 2.5.3, other inclusions of the CBS, that contains some verbiage. All appliances, curtains, drapes, and rugs, and any furniture seller would care to leave inclusions list to be delivered on or before the due diligence deadline.
Okay, thank you.
Welcome.
Right. Any further
Nope.
Questions?
I move to accept staff recommendation.
Do we have a second?
Second.
Thank you, Erica. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Matter
Really
J.
quickly,
Oh,
could
sorry.
we take a 5-minute break just for a bathroom?
Sure. Looks like it's 9:57. Let's just come back at 5 after.
Much appreciated. Thank you.
All right, it looks like we are all back. All right, thank you for that quick break, everybody. I think we are on matter J.
Yeah, matter J is complaint number 2023-2378. The complainants were interested in hiring the respondent to list 2 of their properties for sale. The respondent collected an upfront fee in the amount of $495 from the complainants. The complainants allege that the respondent does not have the right to keep their money because they never signed a listing contract or any type of contract with the respondent. Potential violations include 1210-217-1M, 1210-217-1Q, and Rule 5.20. Disciplinary recommendations are a coursework in ethics, diversion, and a fine of $1,000. And Investigator Peters can answer any questions that you might have.
Great, thank you. Any discussion?
So were they ever asked why they paid the invoice? Because it wasn't paid until November, and the exclusive right to sell was done prior to that. Well, yes, it was done prior to that. Was that ever asked why they paid it when nothing was done?
Yes, I did ask them, Commissioner Lind, and they were a little hesitant to talk about that, why they paid it. But at the same time, they said that they felt comfortable after a conversation with the respondent enough to pay that fee.
Okay, any other questions?
No.
May
I
I
move
get
to
a,
accept staff recommendation.
thank you. We have a second?
I'll second.
Thank you, Autumn. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes.
All right, moving on to matter K, that's complaint number 2024-840. The complaint alleged that the respondent acted incompetently as the listing broker of a vacant property. The respondent failed to notice that the person alleging to be the owner of the property sometimes reversed the owner's first and last names and sometimes misspelled the name entirely. The respondent failed to request an ownership and encumbrance report from the title company to notice that unlike the quote seller's representation, the owner actually lived in Denver, not out of state. The complaint alleged that the respondent's failure to properly confirm the seller's identity resulted in the complainant falling victim to land fraud, losing $8,000 to $10,000 in out-of-pocket expenses and unnecessarily selling his primary residence. It appears that the respondent may have failed to provide the complainant with an affiliated business arrangement disclosure. The respondent recommended a title company affiliated with the respondent's brokerage. It was a title company which, according to the complainant's allegations, also failed to take proper precautions to confirm the seller's identity and allowed the transaction to close despite red flags of the fraud. Possible violations are 1210-217-1Q, 1210-217-1M, and Rule 5.21. The disciplinary recommendation is a fine of $2,500, coursework in brokerage relationships, coursework in contracts, and diversion. Investigator Hardy is out of the office today, but I am here to answer any questions you may have.
All right. Questions, comments?
I think it's amazing they got the money back.
Yeah.
Yes.
Very rare.
I kind of feel like this discipline is too light, which is rare coming from me. I just, you know, these poor buyers, right? And I don't know. I'm so glad they got, money back, but just everything they went through. I just feel like, and I can't remember how long this broker has been licensed.
About 4 years.
How many?
4 years.
4. Okay.
He said in that time he's done 700 transactions, however.
Which is impossible. So that doesn't.
I just feel like it's too late. This needs to be really an eye-opening experience, I think, for this broker. I don't know. Commissioners, what do you think?
Do we know, and I know this isn't our job to police this, but do we know if they ever got any money back for the money they had put into the land?
We don't know that. They did not say that they did,
Okay.
nor did anyone insinuate that they would be getting that.
Okay.
Erica, Autumn, thoughts?
This concerned me on so many levels. I mean, there was so much going on here that you have the scammers that are involved pushing to all texting, but that the clarifications and the red flags that just did not happen are very unnerving. A lot more questions should have been asked on numerous levels. So I completely agree with Michelle that I feel like more should happen in this regard, but it definitely goes beyond this case. So I'm with you on that one. I'm not sure what that should be or what that could be.
What are you recommending, Michelle?
Well, I definitely think we should maximize the fine, and I think we need an FAO, not a diversion.
Okay, so fine of 5,000.
I'm okay with 5,000.
I would be okay with that.
Because normally we don't do the second one, right?
Right. Mm-hmm.
So, okay. So do you want to make a motion or?
I don't know if as a chair I can make a motion.
Okay, Erica, you want to?
In Commission Matter X, I recommend a fine.
Hey, sorry.
K. K. I recommend a fine of $5,000 and changing from diversion to FAO, coursework and brokerage relationships, coursework and contracts.
Okay. Second.
Right. Any further discussion? All those in favor?
Aye.
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 Motion passes.
All right. Commission Matter L is complaint number 2023-1649. While under contract to purchase the subject property and without the consent of the seller or the seller's agent, the respondent provided unauthorized access to the property to another brokerage firm's agent in order to show the property to a prospective subsequent investor. The respondent's previous employing broker was disciplined by the division for similar conduct. Possible violations are 1210-217-1M, 1210-217-1Q, 1210-217-1W, and Rule 6.16. The disciplinary recommendation is a final agency order, coursework and ethics, and a fine of $2,500. And Investigator Rakay is here to answer any questions you may have.
Thank you. Any questions on this one?
Nope. I move to accept staff recommendation.
All right. We have a second.
Second.
Thank you, Erica. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Good morning, commissioners.
Morning.
Your next item is investigative matter N, which is complaint number 2023-1268.
What
on
about
June
M?
3rd.
We didn't do M as in Mary. Sorry.
Yeah.
So
you're right,
Commissioners,
yeah.
My
if we can
apologies.
take them out of order, Nicole has gotten kicked out due to her internet. So
Oh,
if Eddie
okay.
can go so that Nicole can get logged back in.
Oh, my
Okay.
apologies. Sorry, I was jumping ahead.
Okay.
Currently, your next investigative matter is investigative matter N, which is complaint number 2023-1268. And your next two items are kind of a set. On June 30th, 2023, complaint number 2023-1268 was filed against the respondent, stating the respondent took over the complainant's lease when the respondent acquired the book of business from the former property management company. The complainant stated he wasn't allowed to renew his lease because the owner decided to sell the unit. The complainant stated his entire security deposit was retained along with additional tenant charges of over $800 upon move out. The complainant stated he returned the unit in the same condition he received it in. The complainant stated he wasn't told he was responsible for recaulking the bathroom or cleaning the mold and mildew in the unit. The respondent currently manages approximately 1,450 doors. A sample of 35 security deposit settlements were reviewed. The sample shows that 33 of the 34 settlements performed by the respondent didn't have invoices for charges taken against the security deposit funds. The respondent provides the tenant with a document labeled tenant charges that states estimate prepared by that the respondent states is the actual bill used to charge the tenant. The respondent then transfers the security deposit to the owner's ledger and assesses the tenant charges against the owner's ledger. The sample showed that no tenant received a refund of their entire security deposit and that 10 of the 35 settlements received less than 40% of their original security deposits. And the respondent retained approximately 50% of all partially refunded security deposits. The respondent sent 9 out of 35 of the settlements to collections, despite owners being allowed to use their own vendors, creating scenarios where tenants are assessed charges for work that hasn't been completed, as well as transferring security deposits to owners without proper tenant disclosure, consent, and subsequently sending the accounts to collections in the process. In this case, the respondent transferred the owner the complainant's full $1,440 security deposit without actual invoices or receipts to document work completed, and the owner didn't use the respondent to complete the repairs. The complainant was sent to collections and owes over $1,000. There is no photo documentation of the unit at move-in, but there is photo documentation of the unit at move-out. Sampled settlements appear to show that the respondent is charging tenants for items that may be considered normal wear and tear and items that are not listed in the respective leases. Recommended discipline or possible violations include 12-10-2171I, converting, diverting, commingling funds, 12-10-2171M, violation of any commission rule, 12-10-2171Q, unworthy incompetent practice, 12-10-2171T, undisclosed compensation, and Rule 5.8, transfer of security deposits. Recommended disciplinary action includes a stipulation for diversion, a fine of $2,500, and an audit to coincide with the follow-up audit listed in complaint number 2023-569. And myself and investigator Marcy Rivera are here to answer any questions you may have.
Whenever money was transferred over for repairs to the owners, was there any follow-up done to see if they did those repairs? My thought on that was that if that was transferred over to the owners, no follow-up, that same repair could be charged to the next tenant and it's just a cycle.
Correct. I will let Marcy jump in. She might have a better answer on this specific question, but the goal of the follow-up audit will be to review these security deposit settlements in a little bit more detail, and we will have a definitely a better determination of that going forward.
Okay, thank you.
Well, the problem with if they're selling it, they may not be checking to see if the repairs are done because it's being sold. So it's not like they'd be moving another tenant in. So there is no due diligence on that part.
And I might be able to provide a little bit more information. I do think that the respondent in this case has updated some processes and procedures to include move in and move out reports. This is a situation where this respondent is generally in the business of acquiring books of business from other property management companies. So, there's a good chance that a lot of these were inherited from a previous property management company. So this respondent was not hired by the respective owner at the time the lease was entered into. So There's definitely a large percentage of these that won't have move-in reports and won't have documentation to show, but I think the respondents' processes and procedures moving forward will help better, address the question you just had, where the fact that they're doing move-in and move-out reports would reflect the fact whether the work's been completed or not.
Okay, thank you.
So the condition of the property looked pretty darn good for having a tenant in there. And I think the charges were extremely high. And so, and like the report said, a lot of the things that were being charged should have been normal wear and tear and not something to the tenant. And it almost looked like they were being double charged. They're charged for cleaning and then they were charged for cleaning something else, and that would have been in the normal cleaning. So there were quite a few issues with costs and no invoices.
Renee, what are your thoughts on the discipline on this case?
I think it's okay. We've got a couple cases tied together, so I think it's okay. And then we're going to be doing, the follow-up audits as well.
Okay. Any other questions or comments? Hearing none, may I get a motion?
I motion to accept staff recommendation.
Second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes.
Okay. Next item is investigative matter O. This is complaint number 2023-569. On March 27, 2023, complaint number 2023-569 was filed against the respondent, stating the respondent began managing several of the complainant's units after the respondent acquired the book of business from the complainant's former property management company. The complainant stated in 3 months only, the respondent overcharged and double billed for services and provided inaccurate owner statements. The complainant stated that the respondent is improperly charging tenants against their security deposits. The respondent charged the complainant a $143 fee called general punch list to coordinate repairs without authority. The respondent currently manages 1,450 doors. A sample of 35 security deposit settlements were reviewed. The sample shows that 33 of the 34 settlements performed by the respondent didn't have invoices for charges taken against security deposit funds. The respondent provides the tenant with a document labeled tenant charges that states estimate prepared by that the respondent states is the actual bill used to charge the tenant. The respondent then transfers the security deposit to the owner's ledger and assesses tenant charges against the owner's ledger. The sample showed that no tenant received a refund of their entire security deposit. The sample also showed that 10 of the 35 settlements received less than 40% of their original security deposit, and the respondent retained approximately 50% of all partially refunded security deposits. The respondent sent 9 out of 35 of these settlements to collections, despite owners being allowed to use their own vendors, creating scenarios where tenants are assessed charges for work that hasn't been completed, as well as transferring security deposits to owners without proper tenant disclosure and consent, and subsequently sending the accounts to collections in the process. It appears the respondent is charging tenants for items that may be considered normal wear and tear and items that are not listed in the lease. Furthermore, the respondent failed to credit the respective tenant $580 after the owner successfully disputed one of the tenant charges, and the three-way recons provided by the broker were missing journals, ledgers, and both accounts showed a large volume of unreconciled items dating back years. Possible violations include 12-10-2171H, failure to account for funds received, 12-10-2171I, converting, diverting, and commingling funds, 12-10-2171M, violation of any commission rule, 12-10-2171Q, unworthy and incompetent practice, 12-10-2171T, undisclosed compensation, Rule 5.8, transfer security deposits, Rule 5.14, record keeping requirements, Rule 5.17, markups must obtain prior written consent, Rule 6.2, competency. Recommended disciplinary action includes diversion, a fine of $5,000, coursework in brokerage administration, coursework in property management, coursework in security deposits, coursework in tenant landlord laws, and a follow-up audit within 3 months. And again, I'm here to answer any questions you may have, as well as Marcy Rivera.
Great. Questions, comments? Hearing none, may I get a motion?
Motion to accept staff recommendation.
Second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Thank you, commissioners.
Okay, I'm back for matter M, complaint number 2024-1213. The complainant, who was the buyer of the property, alleged that the respondent, who represented the buyer as an agent, promised a payment of $250 for missing items at closing and has not yet made payment. Possible violations include 1210-217-1C, 1210-217-1Q, 1210-217-1N, and 1210-405. Disciplinary recommendations include coursework and ethics, diversion, and a $1,000 fine. However, an update is that after we notified the respondent that this would go to the commission, he did make a payment of $250 and provided evidence of that.
Okay. Questions or comments?
So it looks like when this was going on, oh, actually, it wasn't when it was going on. It was the following year. We had that E&O violation as well, correct?
Yes.
All right. Do we have a motion?
Motion to accept staff recommendation.
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes. We are now on to licensing matters.
Matter A is a preliminary advisory opinion, complaint number 2024-996. On October 24th, 2019, the Colorado Board of Nursing summarily suspended the applicant's nursing license. On April 12th of 2021, the applicant was issued a stipulation and final agency order in which her nursing license was suspended indefinitely. On August 27th, 2021, the applicant pled guilty to obtaining a controlled substance by deception, a felony, and was sentenced to 3 years supervised probation, which was terminated, and court costs and fees in the amount of $100. Then on April 4th, 2022, the applicant received a letter of admonition for noncompliance with the terms of her discipline related to the suspended license. And we do not have a recommendation as normal. And Investigator Gabarty can answer any questions that you might have.
Discussion?
I would recommend a negative opinion. I think there are multiple things have happened and it hasn't been far enough away. There's not enough time that's passed since the multiple items have occurred.
Is the current license, I'm just going back to that, it is now completely suspended, or is it active on that with some restrictions?
Or are you referring to the applicant's license, RN license?
Yes.
It's active with restrictions.
Sorry, I lost my other screen. Did the applicant take counseling? Were they in counseling for? Sorry, again, I lost my screen. For the controlled substance?
Yes, she has.
Okay. And has met all of those recommendations and everything for her court so what it said she violated, that was for her nursing license, correct? Not for the courts?
That is correct. Is she, give me a second. I'm just taking a peek at the report real quick.
So if I recall, she can practice currently, but can't practice in isolation and has to have close supervision. Is that something we would be able to do with a real estate license, as far as she just has to have close supervision on that? Were she to go forward?
Well, that comes with the first 2 years of a license.
Regardless. Would that end up dropping? I mean, it typically does, yes, but in this one, I guess she's just got the restrictions.
Make it for longer?
Yeah.
Well, this is just a preliminary opinion.
Correct.
So she's not actually applying, she's just getting your opinion, and then she would have to reapply.
But we could do positive opinion with restriction.
Restrictions, right.
So in that case, would it be something like positive opinion with restriction of understanding your license would be 4 years of high level of supervision or something like that?
That's what I'm thinking. And then that coincides with some of the restrictions that her current board has already put on her, because she's done everything else that she needed to do in that regard, it sounds like, from my review.
Yeah, I myself, I'm leaning towards positive opinion. I think, the applicant is working their way back to fixing the issues that they had. And
there were
they still
multiple issues. There were multiple issues where things were told and it wasn't done, or she had a problem with it. It wasn't like everything's just gone, oh, you have a problem and everything's gotten better. It's been an up and down. Isn't that correct?
Which is why I would be okay with restrictions. I mean, if you had continued issues, then you
I think it's too close. The probation just ended. I think there needs to be more time between, so that we can have a better history and
this is
positive history.
This isn't an application, so they still have to pass everything. They still have to take the schooling. They have to pass the state exam, and then it still has to come before us. So, and she still retains her nursing license. They did not strip her of that. So, that's why I would do a positive opinion. Autumn, what are your thoughts on this?
I'm leaning towards positive opinion with restriction.
Okay. All right. Let's get a motion.
Autumn, do you want to make a motion?
I haven't done one before, so I may muddle the words a little bit, so bear with me. I move, or
I motion.
I motion, thank you, for a positive opinion with the 4-year restriction for supervision.
High level of supervision. Yep.
High level. Okay, thank you.
We have a second?
Second.
All right. Any further discussion? All those in favor?
Aye.
Aye. All opposed?
Aye.
Okay. Motion passes with 3 in favor.
Licensing matter B is an application. Complaint number 2024-998. On July 10th of 2008, the applicant's Colorado real estate broker's license was revoked due to a failure to disclose an arrest and conviction for possession of a controlled substance, a Class 4 felony. On August 5th of 2002, the applicant was found guilty of marijuana cultivation, a Class 4 felony. The applicant was ordered to pay $2,662 in court costs and restitution, serve 90 days in jail, complete 48 hours of public service, and complete substance abuse evaluation. The terms of the sentence were completed and probation was terminated. On September 18th of 2008, the applicant pled guilty to possession of controlled substance, Schedule 2, over 1 gram, a Class 4 felony. The applicant was ordered to pay $3,104 in court costs and fees, complete 18 months of probation, and 48 hours of community service. The terms of the sentence have been completed and probation was terminated. On September 18th of 2008, the applicant pled guilty to harassment, insults, taunts, challenges, a Class 3 misdemeanor. The applicant was ordered to pay $248 in court costs and fees and complete 6 months of unsupervised probation. All court costs and fees were paid. Probation was terminated. And we do not have a recommendation, but Investigator Martinez can answer any questions.
All right. Any discussion?
I thought it was weak and no statement. It was lacking in what we normally want to see, explanations and reasons and things. I don't think enough was provided to make a positive decision on.
Okay. I'm trying to remember, did this one have any letters of recommendation?
I was muted. I was just saying that, yes, there are letters of recommendation.
But the personal statements was so.
Well, I think something we have to consider as well is this was 16 years ago. And I don't believe there's been any other problems that have come to light in that time. Is that correct?
That's correct.
Autumn, Erica, what are your thoughts?
I'm just thinking like maybe this isn't here or there, but during the time 2002, when this is prior to marijuana being legal in the state of Colorado, now she could easily apply for a permit to cultivate. I don't know if that matters, but
It's not just the marijuana, though. We've got burglary, criminal trespassing, harassment. We've got drugs. We've got civil penalties. I don't know. There are a lot of things on this, and I have written down there's no personal statement. Maybe I'm wrong, but
I'm looking as well. How old was this person at the time of the original offense in 2002 and again in 08?
23 for the original.
I mean, a lot can change in 16 years from 23 to.
well, we don't normally approve something like this without a strong statement, is what I'm saying. I mean, yeah, someone applied, but they're not giving us any information, any history, any explanation. That's not something we normally do.
Is that something that we can request?
We did request that.
Yeah, and yeah,
Did request
and let's see here. Yeah, we did get the statement, which is Exhibit 5.
Yeah,
but
we have something.
yeah,
It's just very broad.
I just think we have to be very careful. I mean, we've been kind of told before by the AG's office, we have to be very careful. I mean, time has passed. We really have to look at, if we're going to deny, we're denying because they don't have a personal statement. I mean,
No, I don't know why we're making some of these decisions anyway. We're trying to decide if someone's rehabilitated. We are not psychiatrists, psychologists, whatever. This is a little challenging anyway. So,
Right.
I mean, if you want to go, okay, it's been a long time, that's fine. I'm just saying we don't normally do this without some strong statements. But if you want to just do it based on time,
Well, it's not just
Yeah.
time. She did include a statement, that was in there.
I think it was really weak though, wasn't it? Anyway, I'd have to find it again.
Well, I mean, it's not going into great detail. But again, it's not a requirement that they have to submit
No,
that. So,
No, I'm just saying that's something we normally want to see though. But
There was a document included in here that the home that she lived in, they had set up essentially a meth lab. There were all of that, but then one of the cases had been dismissed, and I couldn't tell, was that the case that was dismissed and that was not part of this? Or was that part of these cases as well, that there was distribution and part of that was a meth lab in that house?
So the case that was dismissed, there's actually two, and it is case 01 CR148, and I'll give you the information for that case. Give me 1 second. I'm just opening the court documents. Give me 1 moment. Okay, yes, the dismissed case, the 2001 case, does pertain to the matter that you had described.
Okay, and that was dismissed.
Yes.
Just my 2 cents, again, 16 years ago has had, has worked this whole time according to the resume. Did have a 2 letters of recommendation. I don't feel that we have enough cause to deny an application. I mean, 16 years is a long time. I think if that behavior was repeated, we would definitely be seeing that within that 16 years. So, but those are my 2 cents.
Michelle, I agree with you. I had, my question was answered and resolved. So I would go ahead and move forward with a positive opinion.
It's an application, so it would be approval. Is that still okay?
Yes.
Okay, so we have a motion for full approval. Do we have a second?
I'll second.
So Autumn, any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Okay, sorry, it's not letting me turn on my camera right now, but licensing matter C is complaint number 2024-1296, and this is an application. On May 12th, 2002, the applicant was convicted of theft, a class 4 felony. The applicant was sentenced to a 2-year deferred sentence. The deferment was revoked and they were resentenced to 2 years probation. That probation is concurrent with another case. Probation was terminated unsuccessfully and a fine of $1,184.75 was paid in full. The case is closed. On November 3rd, 2003, the applicant was convicted of a class 5 felony theft. The applicant was sentenced to 2 years probation, 14 days in jail, and a fine of $1,541. The applicant has completed probation and has paid the fine in full. On December 11th, 2003, the applicant was convicted of child abuse, knowing reckless bodily injury, a class 1 misdemeanor. The applicant was sentenced to 6 months in jail, which was suspended, 18 months probation, and a fine of $274. The applicant completed probation and has a $0 balance on the fine. That case is closed. On August 7th, 2014, the applicant was convicted of a pimping attempt, a class 4 felony. The applicant was sentenced to 30 days in jail, 30 days credit for time served, 3 years probation, and a fine of $2,563.50. The applicant has completed probation and has paid the fine in full. There's no recommendation, and Investigator Quintana is here to answer any questions you may have.
All right, discussion.
I was rereading some of the documents in the folder, so just to refresh my memory on this one. So it does look like she put a couple of written statements together along with 2 letters of recommendation.
Yeah, looks like one for each conviction or each issue. She wrote a specific letter. It looks like she's got 3 letters of recommendation and a personal statement besides the explanations.
So I would move for a yes on this one.
Okay.
Second.
All right. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Licensing matter D is complaint number 2024-1119. This is also an application. On April 27th, 2012, the applicant was convicted of felony possession of marijuana and felony possession with intent to deliver. The applicant was sentenced to a 2-year deferment. That deferment was revoked, and he was resentenced to 5 years, 6 months in jail with a fine of $785. That case is closed. On March 22nd, 2013, the applicant was convicted of possession of marijuana, a serious misdemeanor. The applicant was sentenced to 7 days in jail and a fine of $315. The case is closed. On February 14th, 2014, the applicant was convicted of felony second-degree burglary and felony assault causing serious injury. The applicant was sentenced to 10 years in jail and 4 years parole with a fine of $473.80. The applicant was released from parole in 2019, and the case is closed. There's no recommendation, and Investigator Quintana is here to answer any questions.
Thank you. And this applicant has a license in Washington, is that correct?
I believe so.
What I saw, it looks like Washington since 2020. Just curious if there are any issues with that Washington license that we were aware of.
Not that we're aware of, no.
And that's something we normally do. We check with them.
Yeah, they're supposed to report it on their application. And we do generally look on the website.
Okay.
I think he was 18 and 19 at the first offenses, and it's been 10, 12 years.
Yes, that is correct.
So when we approve the application, it would be normal where he would have to be an associate broker and be under someone, correct?
Correct.
Okay, then I move for a yes on this one.
Second.
All right, first and second. Any further discussion? All those in favor?
Aye.
Any opposed? Motion passes.
Can I just ask for some clarification on that? Because if he was licensed in another jurisdiction, we do consider experience towards gaining the independent level and or any advance. So specifically to be an associate broker, and forgive me, I'm having trouble pulling up his application right now to see what he applied as. But if he has
it should be an associate, because you don't know Colorado law. I think anyone coming in should still have to do what we do here when you get your license, is you have to be under somebody for 2 years.
Well, I understand that, but if there is experience from another jurisdiction, that is considered in our licensing upgrades. So I just wanted to be clear on what your expectation was with this one.
I would say that he needs to be an associate broker with oversight for 2 years.
Penny, I have the application up. Where in there does it say what they're looking for? Because it says reciprocal license, but
which means he is probably bringing in some experience. Sarah, do you have it? I'm sorry, I can't seem to get mine to pull up.
Yeah, I do have it. And that's a really good point, Penny. So, he applied for associate, but it does say that he, under the reciprocal education, he put reciprocal education.
But if he's applying for an associate, we approve yes on the associate.
Correct, but if he had 2 years of experience, as soon as he becomes an associate, he could go independent. So that's the concern.
so what we just need to clarify whether we're putting it with restriction of 2 years of.
If your expectation is that he would work for 2 years as a broker associate here in Colorado, you may need to require like a restricted license that he is clear that he needs to remain an associate broker for the 2 years, and that you're not considering experience from another jurisdiction in that upgrade. And if I'm overthinking this, Sarah can tell me to, but it is part of our licensing that if they have experience from another jurisdiction, it is used towards upgrade. And based on what your discussion was, I just wanted to make sure you knew that so that your expectation was clearly understood by us to enforce it.
So I guess we just have to decide, are we wanting to put a 2-year an approval with restriction of associate broker for 2 years?
Yes.
I would agree with that.
Okay, so Renee made the motion. Erica, you made the second. So Renee, you just want to amend that?
Okay, we'll vote for yes on the applicant with a 2-year restriction of associate broker.
Okay. And Erica, you're still good with the second?
Yes.
All right. All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes.
Licensing matter E is complaint number 2024-1187. This is an application. On October 31st, 1991, the applicant was convicted of a felony grand theft of a vehicle. The applicant was sentenced to 120 days jail and 24 months probation. On September 5th, 2003, the applicant was convicted of felony grand theft labor property. The applicant was sentenced to 3 years probation, restitution for $200 and 200 hours of community service. There is no recommendation, and Investigator Quintana is here to answer questions.
And these are so old, that's why we don't have any documentation for the cases, correct?
That is correct.
I would recommend approval on this application.
I didn't have any issues that I saw, so I would second that.
All right. Any further discussion? All those in favor?
Aye.
Any opposed? Motion passes.
Licensing matter F is complaint number 2024-1273. This is a preliminary advisory opinion. On July 18th, 2014, the applicant was convicted of a Class 1 misdemeanor assault with negligent deadly weapon. The applicant was sentenced to 17 days in jail and credit for time served, 2 years probation, and a fine of $278.50. The applicant has completed all terms of probation and has a $0 balance. Also on July 18th, 2014, in a separate case, the applicant was convicted of burglary 2 of building, CSP, a Class 5 felony. The applicant was sentenced to 20 days in jail with 20 days credit for time served, 3 years probation with a fine of $1,959.50. The applicant has completed all terms and the case is closed. On December 12, 2018, the applicant was convicted of trespass 2 motor vehicle, a Class 3 misdemeanor. The applicant was sentenced to 6 months unsupervised probation and a fine of $334.17. The applicant has completed probation and has paid the fine in full, and the case is closed. There's no recommendation, and Investigator Quintana can answer any questions.
All right, any discussion? Thoughts?
I'll vote for a positive opinion.
Yeah, I think that it's been quite a while since he's had an incident, went to rehab, good letter of rec. I would second that.
Okay, so Renee, do you want to make it? I'm sorry, did you make a motion?
Sure. Motion for a positive opinion.
Okay.
We'll do it backwards.
And then Erica, you second?
Yes.
All right. Any other discussion? All those in favor?
Aye.
Any opposed? Motion passes. I suggest we take a really quick 5-minute break, refresh our coffee. We've got ESP matters, and then we have executive session. So are we good with taking maybe a 5-minute break and coming back at 11:05?
That works.
Okay.
Thank you.
All right. Looks like we're all here. Penny, we are now on to ESP matters.
Okay, thank you. The first matter for you is a reconsideration of a licensing decision. When you reviewed this matter, it was disclosed in the application that this individual had discipline in another jurisdiction. The complaint involved an unlicensed entity. He is currently licensed in that jurisdiction where he was subject to discipline. You had offered a restricted license with a 2-year restriction requiring him to work under an approved employing broker for that period of time. And you can see under the proposal for reconsideration portion of the memo, there's some italics language there. That is cut from the email from his attorney, who is asking for reconsideration as to whether you would consider a shorter period of restriction. Just so you know, when a restricted license, when we make an offer of a restricted license like this, if they don't accept it, then it's considered a denial. And so this individual has made a timely request for a hearing. And as part of that, they're asking for this reconsideration. So today you have an option of, accepting something shorter as they're requesting, or sticking with your original decision, in which case this will then be referred over to the Attorney General's office as a license denial case. So that's kind of where we're at, if that makes sense. And if I can answer any questions, I will do my best.
So other than the email from his attorney, we've received nothing else. Like, because sometimes we get more information, but just please reconsider is basically what we got.
Yeah, I think they gave some information initially just about the situation, and that's correct though, Michelle. It's just this argument that they had an issue, they've worked through that issue, they're currently licensed in that jurisdiction and have no additional complaints and would like you to consider this, and you're free to either consider it or to not.
So he's saying they'd like to do a year or less probation, or as an associate.
Which was a little surprising to me to see that in the email, because in our discussion they were asking for no restriction, and then this is what I got in writing. So I'm just forwarding it to you as it was received by me.
And I think this was before I started. Is that accurate? Because I was not recalling this.
When did you start, Erica?
April.
April, yes, this would have been before you.
Okay.
I believe it was in February or April, and I apologize, I usually include that in there. But this was some months ago.
Okay.
Erica, were you able to read the past, like the original license application?
I read what was on where we have here for the license reconsideration. That's all I have.
And the original report was attached, but I apologize, I did not attach the original exhibits, sort of forgetting that some of you might not have been a part of that.
Okay, so there was an issue in California. It looks like when the audit was done, it was closed, and that there was substantial compliance now. Is that correct, Penny?
That's my understanding, yes.
Okay.
And is he still under any disciplinary, like probation or anything in California?
It is my understanding that he is not.
Yeah. So So if he's submitted that he would be willing to do 1 year, I guess the question is, if we're willing to consider a 1 year instead of 2 years.
Right.
So the fact that he's got everything squared away with where he is now, I guess I would be open to doing the 1 year. Michelle? Or...
Yeah, I think as long as he doesn't have like probation or anything currently on his license. Because if he did, I would like our level of supervision to run with that. But if he's not under any probation, then yeah, I think a year would be okay.
And
Okay,
Michelle,
so
forgive me. I don't know. I'm trying to look through the original to see if on the original report it does say, terms of probation, and then it's checked no. So based on this, I was under the impression that he was no longer on a probationary period. If your acceptance of a counteroffer is based on him not having probation in California, then I would state that in the motion. I can confirm that.
Okay.
If in fact there is a probation in effect in California, then we could have it run concurrent. If there isn't, then we could offer the 1 year.
That sounds great. That sounds good. So can we just, I motion to what Penny just said.
1 year, 1 year,
We're going to verify that there is no probation. If there is probation, it will be concurrent and the license won't be without restrictions. We'll go back to the 2 years or be as long as the probation is. Well, no, we didn't say 2 years. Otherwise, if there is no probation currently, we will accept the 1 year with supervision.
Does that work, Penny?
I understand. Yes, I may be.
Whatever Penny said. Yeah.
Okay. Do we have a second?
I'll second.
Thank you, Autumn. All right. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes.
All right. The next matter I have for you is also a reconsideration of a licensing decision. And this is case number 2024-995. And when you reviewed this application, you denied it. There was a couple of things going on here. Obviously, there was a felony conviction that occurred, at least the conduct occurred back in 1999. I believe the conviction was in 2002. It did involve embezzling money from an employer that was in the context of property management. So I understand that this felony was in that context. There was a couple of things, though, that you talked about. One is there was a page missing from her personal statement, or at least there appeared to be sort of a void in that statement, as well as there was an outstanding balance of restitution. And so what I'm giving you today is the original report, and I have included the full personal statement. There was, in fact, a page missing, which for me anyways, it was informative just to get the full context of what was occurring. No. As well as she's included a documentation of the payments that she had been making. And just for reference, this shows a pattern of consistent payments throughout time. Then it got to a point where it's my understanding that there was an unfortunate loss in the family that resulted in inheriting a bit of money that allowed her to pay the balance of the restitution in full. So she has taken full responsibility for that. So this is before you now to just reconsider based on having her full statement of what occurred and what she's done since then, as well as demonstrating that she's made full restitution and taken responsibility for that previous digression.
I appreciate the clarification on the money, because honestly, I was a little taken back by that, because that is a large amount of money.
We've seen that before, and I think it does raise red flags as to what occurred, and that's why I thought it was important. I normally wouldn't get into somebody's personal, but I think it is important to know that they came into that and therefore took care of their responsibilities, which I thought was commendable.
Well, especially where the original complaint came from.
Yeah.
I mean, I think it's a valid concern in this case, why we would ask how that came about. So thank you for that. That does alleviate some questions I had there.
Yeah. So because this is a new application with no experience outside of the state, this person, if you were to approve, would be subject to the 2 years of high level of supervision as any associate broker would be.
Yeah. I would recommend approval now instead, based on the information that was submitted.
Okay. We have a second?
I'll second it to get into discussion.
Okay. What did you want to discuss, Erica?
I did have a question. Was this the original letter, or is this a revised letter that we reviewed last time?
It's the original letter, including the missing page that was somewhere in the middle. I honestly, I can't remember if it was the second, third, or fourth. It was one of the second or third page was missing.
Okay.
So it kind of jumped in a manner that didn't make sense. So when I spoke to her, so she received notification of the denial. She timely reached out to me. I asked her about that, and she did follow up and send me that missing page. And I looked at it, and it is the same statement, just with the page that was somehow got lost in the uploading or something. I'm not sure.
And that's totally understandable. So I understand that. There's a piece in my memory that I want to go back to make sure that I'm recalling it for this particular case or not. There seemed to be a financial discrepancy from another employer that she worked for that was not referenced in this, and I thought it was Norwest Bank. What am I recalling incorrectly? It's not referenced in here. And so so she didn't just have a discrepancy with the employer on this one. Had she had a termination at one point from Norwest Bank for financial misdealings?
That is part of this.
And if I am misinterpreting if my recollection is off on that, please correct me. It's just not in this.
Yeah, I don't have a recollection of that related to this. I'm quickly looking back through the report. I don't recall anything mentioned in the report regarding that. That certainly would have been something that we would have included.
Because I believe that my issue was that this was so closely tied to funds going missing in property management and in real estate and in finance. And so that's my hang up on it. Even though it was a long time ago, it's just, that's our industry. And so I was concerned about that. It looks like, I'm very pleased that she has taken care of the financial restitution portion of that. Was incredibly surprising to see that. And I'm thankful that that was rectified, and thank you for the explanation. So that was, if I must be recalling incorrectly, but that was the clarification that I was looking for, Penny, on that one.
Okay.
It's easy to do. We have a lot of cases. Sometimes they mush together.
Yes, we do.
All right, so we have a first and a second. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes for approval.
Okay, the next matter I have for you is case number X 2023-101. And this began as a random audit, not a consumer complaint. And the respondent was hired by two licensees to market a property that they were turning as a wholesale transaction. The two licensees had a power of attorney for the actual owner. Review of the transaction shows that there were some missing contract documents, and there were some administrative inconsistencies between the documents and the MLS in terms of going under contract when, etc. When you all reviewed this case, you voted for a stipulation for diversion, a fine of $5,000, coursework in ethics, and a probation with a downgrade for 2 years of high level of supervision. When you reviewed this case, you reviewed it along with the two cases that involved the two licensees that were doing the wholesale transaction. And there were issues with those individuals and with the transaction in general from a wholesale standpoint. In looking at this case a little closer, and I have worked with Eddie Rose, who is the audit team lead. We've looked at this case a little bit closer and realized that based on the information that we have, that what they're offering, or what they're offering, they're offering a letter of admonition with coursework. We don't usually do a letter of admonition with coursework. If you want a requirement of coursework, it would be through a stipulation for diversion. But we did think that this was worth your reconsideration based on sort of the evidence that we have in this case and his role in it. And not, there's some evidence to suggest that the other two players hired and used him to sort of absolve themselves of some responsibility. But he was acting in what he thought was just working for somebody that had a power of attorney for the seller. And, you know, there were some administrative errors, but not, he wasn't complicit, just any defrauding of the seller.
Okay, so based on that, the downgrade with 2-year high-level supervision, I would say we could probably remove then. But you're saying the coursework goes with diversion, so that we would still do diversion and coursework. The question then becomes, is there any fine that we should, I mean, the $5,000 fine obviously sounds extremely high based on what you're saying now. So do we want a fine? And if so, how much? And are we good changing the other to a diversion?
Well, he did also already take ethics as a
I think he took 4 hours, is that right? Or did he take 8 or 4?
Yeah, I believe it was, I think I attached the certificate. He took, it's 4 hours, and that's usually what we ask for because the classes are 4 hours.
Okay.
And thank you for reminding me of that. I'm sorry, I meant to point that out as well, that, you know, I think in good faith, he was, you know, he wants to work with the commission, wants to do the right thing. So he did jump on taking that course. So if you felt like a letter of admonition was appropriate, he has already used that, taken the coursework in ethics. So there's no reason to sort of memorialize that in the diversion.
Okay.
So would we be able to, Penny, just do a letter of admonition and just not even ask for the coursework so it doesn't go to a diversion?
Correct. Since he's already taken that.
I mean, I think with all the new information, I'm okay with just the letter. I mean, he hasn't had any previous action. And with the new information, I think, for me, I think that would be okay.
There were some very strange dealings with this purchase price, and he was involved in that. So that's my hesitation about just doing a letter.
Okay.
Because
and he was acting at the, so if the seller is instructing, him to do certain things with the pricing, that's what he is supposed to do. He was working with somebody that had a legitimate power of attorney in place, so he was listening to them. He has acknowledged that he doesn't want anything to do with these kind of wholesale transactions. I think he learned something from this, and this isn't, I think that the likelihood of seeing this individual in this circumstance again is zero. And I think even moving with caution if he's ever faced with a power of attorney again. So I think that, based on what we have, this is an acceptable way to resolve this one.
Just doing the letter?
Mm-hmm.
Okay.
Yes.
Okay. All right. Well, then I guess I'll make a motion for the letter of admonition, and we won't include the coursework because it's already been done.
Okay, do we have a second? Was that you, Autumn?
I'll second.
Oh, sorry. I wasn't sure who I saw. I apologize.
You gotta be quick.
All right, we have a first and a second. Any further discussion? All those in favor?
Aye.
Any opposed? Motion passes.
Okay. The next one, and forgive me, I'm not sure why the memo didn't come with this. I'm not quite sure what to call this one. It came to my attention as a STIP violation because this individual hadn't completed the required coursework that you had asked for. You had asked for, and the language in the stipulation is for 4 hours or more, and then the coursework subject that is identified is in supervision. And at the time that recommendation was made to you, in good faith, there was at least one class that we identified with the subject matter of supervision that was offered at the time for 4 hours. In those diversionary STIPs, we do specifically say or more, because we know courses change and sometimes the number of hours change, etc. So the minimum was expected was 4 hours. So this individual submitted 2 certificates of completion that were in completely unrelated subject matters. And so we said, nope, it's got to be in the subject matter of supervision. We sent a link with to our website that has all of the commission approved courses on it. And through sorting and looking at that, they identified this one class, contacted the provider. It's no longer being offered. So in having difficulty in locating a class in supervision, I presented the worst case option, which is you might have to take the brokerage administration course. I understand that's 24 hours. The subject matter is what's important here, a minimum of 4 hours and the subject matter. And this has sort of escalated into a situation where I did not feel it was appropriate for me to approve a subject matter different than what you had asked for. And they are arguing that the stipulation for diversion was unclear. In one of his arguments to me, he indicated he thought that by listing supervision in the paragraph of the required education, he thought that meant that the courses themselves had to be supervised, which doesn't really make sense to me because it didn't occur either. If you look at page 27 of the packet, you can see paragraph 7B where the coursework is outlined. as to the 4 hours or more, and then the subject matter supervision. So I guess this comes back to you looking for guidance. I don't think at this point we want to proceed with a SIP violation, but I think what, if your interest is for this individual to have coursework in the subject matter of supervision, then they have to, I think, look at the 4 hours or more and understand that the class might be longer in length than the 4 hours to comply with this stipulation. Otherwise, you can see the 2 certificates. One was property inspection issues, a 2-hour class, and then one in did you serve identifying home buying advantages for veterans, which don't relate to supervision. The original complaint had to do with sort of inappropriate advice that was given to an associate about sign crossing and that issue. So, that's why we asked for the coursework in supervision. So with that, if you have any questions for me, I'm sorry. I know this is sort of a out there situation.
When you said originally, we said we need a 4-hour plus course in supervision, you said there was one class offered. You said later it's not offered, or what was it really offered to start with or not?
Yeah, so when I look it up on our website, it's an approved course, and it's approved through, a certain amount of time, which we're still within. But when this individual reached out to that provider, they're not currently offering it. And we do see that happen. We see, courses come and go and change. And I think, different providers change what they offer, even if it is approved for them to.
Okay, so it's not like he missed it. It's not like it was going to be going on right away and he missed it, and then this is no fault of his. Okay.
A little bit of a reading comprehension issue, but not, something that intentionally he did wrong.
Okay.
My question, just for clarification though, he took his classes through CE Shop. I'm sure CE Shop has something regarding supervision on their website for classes, but is there a way? I mean, we know what to expect when we're looking at these, but for those who maybe aren't interpreting what it says, is there a clearer way for us to maybe put it in the STIP? I don't know, of what we're looking for.
I can look at that with your counsel, and it, and maybe it just the wording there when it says the required courses are as followed: supervision. So I have this conversation with folks a lot. We try not to give the actual title of a course because we don't want to appear as though we're directing people to a particular provider or have favoritism there. So This has always been subject matter. Like you have asked for people to take coursework in ethics or in contracts or in brokerage relationships. So it has always been the subject matter that has, I'm 18 years in, and this is the first time this has come up for me. So I don't think it's a huge problem. I will look at to see if we can make this clear so that this doesn't come up again. But the question for you today is, if you want to hold him to this, agreement, what I would ask is that we give him additional time before we would call it a STIP violation. I think the order is clear that says, if you can find a 4-hour course, take it, but if not, or more. And so we do know that there is at the very least brokerage administration, which deals with supervision, but give him perhaps, 2 additional months or something to comply with that. If we can't get that complied with, I'll bring it back to you at your next meeting, but I don't want to jump into a STIP violation case today. I was hoping just that you would give him guidance that the subject matter does need to be supervision, a minimum of 4 hours, a maximum of there is no maximum. It's
Okay,
just a
so,
4
so
hours minimum.
I would agree we don't need to do a STIP violation. We don't need to do that. Can we go ahead and give him an additional 60 days? If we give him it at 60 days, there should be a course in dealing with supervision that shows up in that period. Is that reasonable?
I can tell you that I have searched, I have looked.
Okay.
And I'm not absent calling all the providers. I don't have the time to do that for every licensee that this, but I have searched, and what I see available today is the brokerage administration course. I'm not seeing anything else. If he can find something else, then, again, we're just looking for subject matter of supervision. So
I can understand that he doesn't want to take a 24-hour class. I can totally understand that if we've only required 4. So I get that. That's why I'm wondering if we give him more time. If it's 60 days, do we do 90 days? It's coming up towards the end of the year when people are needing to make sure they've got all their CE. Maybe more classes will be offered. Maybe he can find something online through some of the schools. What's reasonable? I don't know. Michelle, do you have any input? Like 60 days, 90 days?
I would say, well, 2 things. One, I mean, he did these right away, right? So that's good. That is something in his favor. He did these right away. And from personal experience, there are classes that are not in high demand, so they're not offered very often. And I think this is one of those topics. So I would say giving him at least 60 days to, I hate to have someone do 24 hours to do
right
4, especially because they can't, the broker, this course, they can only use once in their license, correct? Penny?
Well, no coursework that they take for a disciplinary action can be used towards their required education. That's in statute. The 4 hours that he has already submitted, he could use towards his continuing ed if we don't use it for the stipulation. But any number of hours that he takes to comply with the stipulation cannot be used towards their required 24 hours.
Can we say 90 days? Can we say 90, and that if he can't find something in that he can contact you, Penny, and maybe run a couple other courses by you? It has to be somewhat relevant.
What is, I'm sorry, I lost my train of thought. What I meant was the broker reactivation just by itself can only, not even using it for this, can only be used once in their license though, right?
Yeah, and we're not talking about the broker reactivation because that doesn't necessarily cover supervision. We're talking about brokerage administration, which, he has taken in the past because he's an ER.
Right.
So, but his issues, if you look at the violations in his stipulation, they are related to his duties as a supervisor and the, advice and supervision he gave an associate broker. So to say he already took the brokerage administration, I don't think is effective because he's taken it and then he still made these errors. So that's why we wanted additional education around supervision.
Yeah, I think giving him time is fine. It doesn't need to be a STIP violation.
So I heard 90 days as the last, that will offer an additional 90 days to comply with this. And that we are looking at, you know, a 4-hour or more class in the subject of supervision.
Yes. I'm good with
Okay.
that. Renee, are you good with that?
Yes, and I would say if if he gets to the point where he can't find something, he needs to get in touch with you and maybe say, okay, how about these classes? They're not exactly supervision, but would this count? And you could actually bring it back, you know, and ask us or something. I don't know. Do we do that or just give you the authority to do it?
You know, I mean, that's what these classes that he submitted, they're not supervision. That's what he's submitting. So
Well,
if
they
these
don't
are
have
su-
anything to do with supervision. So,
right.
but there's
And
got to be
so,
some other classes that might have, you know, it might be more in line. These definitely are not.
yeah, it's been surprisingly difficult. I will give this individual that. It has been, like, I have spent more time than I probably should looking as well. And, you know, it's not a subject matter that is frequently offered. So
Could
I will,
we,
and maybe we should do this through a motion just for the purposes, in the event that it gets to a STIP violation, that you are allowing a 90-day extension of time
okay,
from today to
what,
comply with this order.
what about, you know, the 24-hour course? Would we know which day of that course would deal more with the violation, the supervision area? Could we say, okay, you need to take, instead of the 24-hour course, you can take day 2 of it because that deals with more of the area where we had the violation. And just trying to come up with other ideas if there's not a course to take. Yes, it'd be 8 hours, but we can't really narrow down a 4-hour specific on a day, but maybe we could narrow it down to which day in the course might be.
I appreciate the creativity, but I think
Yeah.
we're going down a difficult road when we start
Okay.
that kind of
All right.
slicing of courses.
I have a suggestion, Penny, since this is doing with broker, employing broker basically experience, right? I know there is a place on the application. There are certain classes that are approved for that experience, not necessarily supervision, but there is, it's marked, sorry, I was looking it up. Role 2.5 C3A III. So it's class approved for employing broker experience. That
Yeah,
could be
and that
an
was
alternative.
raised. That was raised, but that is, again, every class that I looked at that dealt with that was not related to their duties as a supervisor. Like, I was given, you know, he submitted a class that was in, I think it was brokerage relationships, that is, you can be used towards credits to get your employing broker, but it has nothing to do with, you know, supervising other associates, which is what this was specifically about, his complaint. So,
Okay. So how about if we make a motion that there's not a STIP violation at this time, we're going to give him 90 days to complete a course, and that Penny will have approval on the course. If he's running into issues, he's going to contact Penny to get approval on a course. Can we do that?
I think rather than giving me, you know, carte blanche, you know, approval on the course, if you want this individual to take courses that relate to supervision, I think the order says you have to take 4 hours or more. And unfortunately, his is falling into the or more category. I get that that's frustrating. I get that, you know, it's not ideal. With the amount of time we've I've spent communicating with this individual already regarding this. That course could have been taken and done and moved on. So I think that, you know, at this point, I would ask that you give him the additional 90 days to comply with the order. If that can't happen, then I will come back to you at your next, or, you know, after that with an alternative suggestion of, I don't know, we'll just take it from there. But I think at this point, you know, this individual was arguing that this was not a STIP violation. I did not feel comfortable proceeding with a STIP violation, even though technically it was, without giving him a little more guidance. And I just wanted to make sure that was your guidance and not my guidance. And so I think at this point, more time to comply is the way to go.
Penny, I do have one question. I appreciate all the effort you've put into this as well. And I can see his frustration I could see how he might want to have your approval if he's looking for these classes and it's not necessarily the brokerage administration. If he were to at least submit something to say, will this work? Would you be able to tell him, yes, I would accept that? So that you're not necessarily sending him classes that are acceptable. But if he found something, you're able to review and you're saying, yes, we'll go ahead and accept that. Because right now, nobody's able to necessarily find anything except for that brokerage administration class, but something might pop up between now and the end of the year, since a lot of the providers know people are trying to take classes before the end of the year. Would that be, I assume that would be helpful for him before he takes another class and then it's denied.
Yes, and just so you know, that's typically how this goes. People contact me and they ask, and, you know, for example, I feel like if this individual had sent me a course specifically related to sign crossing, that would have been perhaps more acceptable than, you know, something else. So we really do try to make sure that whatever the coursework that you're asking for goes towards remediating whatever the issues were. And so we need some kind of connection. And so I appreciate that you're okay with me accepting that, as long as you understand that's what I would be looking for, is a connection to the conduct.
Perfect. Thank you.
All right. Do we need to make a motion for the extension of 90 days or?
I would prefer it just for the record, just to kind of be clear.
Okay, so a motion that we do no current STIP violation, we do an extension of 90 days to complete the class, and that if there's an issue, Penny will make the decision on the class or bring it back to us.
Okay, we have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
All right, my next matter for you is case number 2023-1370. This individual's, let's see, so this was a final agency order, not a stipulation. This was a result of moving through the administrative process. And that was signed in May of 2024, requiring a fine, some coursework, public censure, and this individual has not complied with those issues. They are currently inactive, but they do still hold the property right to the license, and they will for some time. And so we're bringing it back to you as a violation of a lawful order. In those circumstances, we typically seek an additional fine of $2,500, a final agency public censure, and a revocation of the license. It doesn't appear as though this individual has any interest in this license. They did not participate fully, even in the administrative proceeding that resulted in this order. So
Okay.
If you want to move forward with a stip violation, or not a stip violation, forgive me, and violation of the lawful order, then that would be our recommendation.
Okay, so I move that we approve the recommendation.
Right, do we have a second?
Second.
Right. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
All right. The last one is case number 2024-260, and this is a violation of a stipulation. This individual was subject to a continuing education audit, was deficient, then signed an agreement with the commission to pay a fine and to complete some coursework, and they have paid the fine. They have not taken their coursework, and it's my understanding that they have then recently gone inactive. So, unfortunately, we've seen a fair amount of these. The stipulation for diversion itself in paragraph 12 outlines that if the respondent agrees that if they are in violation of this order, that the commission will proceed with a formal disciplinary action, which is what we're recommending. So a fine of $2,500, a final agency order, and a public censure. And I would ask that if the that the commission give me the settlement authority of obtaining a relinquishment if they're no longer interested in the license. We would stay the coursework, and it would only be due if they ever reapply. And if they don't respond to that, then we just proceed with the violation of the order with the recommended discipline.
All right, any discussion?
No.
Motion?
I move to accept staff recommendation or Penny's recommendation, and also to give her power for relinquishment. What did you say, Penny, exactly?
Yeah, to accept a relinquishment.
Accept, okay.
You know, staying the you know,
Okay. Give Penny the power to do that.
All right, do we have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes.
And that is all I have for you today.
All right, thank you. We are going to go into executive session now, if that is okay with the commissioners. Gonna read my little prompt here. This is Commission Chair Michelle Espinoza. This is a Colorado Real Estate Commission meeting on October 1st, 2024, and the time is now 11:55 a.m. I move that the commission enter into executive session pursuant to Colorado Revised Statute Section 24-6-4023A2 for the following purpose: to confer with counsel to receive legal advice on specific legal questions regarding proposed CP 30, a commission position on data security and privacy. Specifically, the commission would like advice from counsel regarding the legal implications of position statements generally, as well as implications of the specific guidance proposed in this position statement 30. Is there a second?
Second.
Thank you, Renee. All those in favor?
Aye.
Aye. There are 4 votes in favor of executive session. We will now enter into executive session. Please make sure your audio and your video are off in this session before you join the other one.
Commissioners, I just want to flag for you before you get back into discussion that Tracy Dowd is still, she still appears to be with us. So if you have questions for her.
Okay, I think we're still waiting for Autumn.
I'm here. Can you guys not see me?
Oh, we just can't see you.
Oh, weird. I don't know why.
We had to shut off your camera during executive session.
Okay. So I don't know if you guys can turn her back on your side or, but let's, why that is happening. Autumn, you can hear us though, right?
Commissioners, I just unlocked her camera, so she should be able to turn it back on herself now. I apologize about that.
Okay. I don't, Autumn, can you hear? Well, now she lost her audio. Autumn, can you hear us? Now we can see you.
Okay, trying again. Can you hear me?
Yep, we can. We can hear and see you.
Apologies. I had to log out and log back in.
Nope, you're good. Okay. I think it maybe a good way to maybe approach this is maybe take it block by block on this instead of just an overview. Is that okay?
Good idea.
Could we just put something at the very top about that this is a recommendation, a guideline? Is there just some minor verbiage we could put at the very top?
So I think with the manual and also with the website, we will put some information to clarify what the positions do or what the position statements do. So it'll be clear on the website and also in the manual that the position statements are simply guidance.
Okay, that would be great.
Marcia, if we get this approved today, is this something that would come out in the newsletter?
We would probably send out an email blast. It would come out in one of our monthly emails first.
Okay, and then on that, we could also clarify, I mean, do it for the whole, just so that everybody understands CP statements, but maybe give a little clarification when that goes out of what the purpose of the commission position statements are for. That way if people aren't in their manual right now or whatever, at least we're doing our due diligence of reminding them what the statements are used or the position statements are used for. Is that okay, Renee? Does that?
Yeah, if we could put something like Marcia said about that this is guidance, if we could use verbiage like that, we need to put that would be great.
All right. So we're looking now at the first paragraph. When it starts with real estate transactions involve the exchange of. With that specific paragraph, is there any recommendations or concern within that paragraph? Renee, do you have any concerns with that first paragraph?
No, are we going through every paragraph individually? Do we, I mean,
Well, there's what, 10, 12 paragraphs.
okay,
Unless you guys have specific areas that I just don't want to miss something or kind of go backwards, is the only reason I suggested we go paragraph by paragraph. So, there's no problems there.
I mean, it's all fine if it's a guideline. The whole thing is fine. So,
It's a guideline. So,
it's fine.
okay. So Erica, Autumn, in reviewing of the rest of the form or the statement, do you have any concerns or recommendations for the
No,
statement?
I like the first paragraph. I'm just going to the second paragraph. It is also not on screen for anybody to see. Is that where?
No, it's not on screen. We have to go in and get it.
No, I have it in front of me. I just didn't know if that's something we're putting.
I'll see if Doreen can pull it up.
But no, does anybody have any issues with the contents or anything in there? Or?
I do not.
I don't have any problems with it. Erica, did you have a chance to read it prior to?
I did. Yep.
Was there anything that stuck out to you that you had an issue with?
No, I appreciate that they incorporated a lot of the additional comments. I think that is covering quite a bit and explains what we need to a large degree.
Okay.
I don't know, unless, we have this one where it says protect networks and devices, and we've got the word must. Wi-Fi networks must be secured. And so that's my concern, where we say must, then that doesn't sound like a guideline. So most of the verbiage is should or recommend, but the word must to me does not sound like a guideline.
That should be in line with the other ones that were changed to should.
Yeah,
or recommended.
So I would say if we have a must, we should change the word to should, since it's a guideline. So maybe we can, if someone's going to go through and search for the word must and look and change it to should instead of must.
Marcia, can we make those adjustments?
We can do that easily.
Okay.
And then I know on a lot of them, we had changed the word from licensee to broker. We still have quite a few words of licensee in here as well. I don't know if we're trying to change them all to broker.
We can make that change as well.
Okay.
All right. Anything else?
So the third-party vendors towards the bottom, we're saying if you do third-party vendors, you need to review their policy to ensure that the vendors meet our security standards. Again, that would be one of those that sounds like it's a must rather than a should. I don't know if we can change the verbiage on that. I mean, I personally don't know how property managers are going to talk to their software providers and make sure they're doing certain things. So I don't know if we could change that. I'm not sure which verbiage we would change, but
Maybe when engaging third-party vendors to whom you're providing sensitive information, comma, it is recommended that you thoroughly review.
okay, that'd be great.
Also, to be clear, I don't think it says that it should meet a commission standard. It's just asking that it meets your standards. So as you evaluate who you want to use as a third party, make sure that they're doing what you're needing them to do.
Okay, well, that's true. Okay, so maybe we don't need to change that.
Okay. Okay.
All right.
I think that having that clarification come from the division when this is released on what CP statements are, hopefully that would alleviate any question on that this is something that is highly recommended as a best practice and not a required rule. Again, if it was a rule, we would have voted on it in January. So before we vote, is there any other things that are standing out?
I say we just stop doing wire transfers. We go back to the old days when people went to the bank and got a cashier's check. And then we don't have the issue with wire transfers.
All right. With hearing no new recommendations for changes, I think we need to get a motion to approve CP 30 with the changes of the verbiage for brokers and should throughout the document.
Yeah, take out the must and put in should. And I actually would like some, a clarifying something at the top of this one specifically saying that it is a guideline.
Well, if you're going to do that, you're going to need to do it for every single one because it's going to cause confusion with the brokers. Why does it say it on this one and not this one? So I think with it being on the website and in the book and with the extra thing that Marcia is going to send, I mean, we either have to do it on all or not just one. I think that causes more confusion because then people are going to say, well, the other ones, why is it different from the other ones of what is being asked?
Well, there's not anything in, well, maybe there is, I don't know. Is there something in the book right now that deals with this? Because a lot of the other position statements, there's something in the book and we're actually clarifying that rule and we're putting in a position statement that says this is how we're interpreting this. But for this one, is there something actually in the book that says this is how we're interpreting it? This is kind of odd because it's kind of by itself, isn't it?
Well, it's going with the rule. It cites the rule in the first paragraph.
Well, okay, but is that rule dealing with this whole document? I thought that rule was just that rule is specific to something else. It's not dealing with its whole document, correct?
Right, destruction or disposal of PII. Marcia, I'm sorry to cut you off.
So this goes in with the body of position statements, which are in chapter 3. There would be 30 of them if you adopt this one. There's nothing in that chapter that leads off saying that all 30 of those are just guidance. But it hasn't been a point of confusion previously. And it's pretty typical when you go through the position statements that they are citing rules and statutes so that the licensee knows where else to look for additional information.
And that's something that we had discussed earlier that we'll be adding something to chapter 3, right, on the guidance of the statements.
We have time before we publish the 2025 manual that we will put something in chapter 3 that puts everybody on notice that these are not regulations, they're just guidance.
Okay. All right. Are we ready for a motion? Someone willing to do a motion?
Okay. I move that we approve CP 30 commission position on data security and privacy with the changes proposed.
Okay, we have a second?
I'll second.
Any further discussion? All those in favor?
Aye.
Aye. Any opposed? All right, motion passes. All right. I feel like this was a little bit of a rough meeting, everybody. So thank you for sticking it through and being such willing participants. And thank you to the division staff for all your hard work. We are officially adjourned at 12:27. We will see everybody in December.
Thank you, everybody.